In today's video, I will explain the concept of judicial separation and divorce. So first, I'll explain the concept of judicial separation. So judicial separation is a medium under the law to give some time for self-analysis to both the parties of a disturbed married life. Law give a chance to both the husband and wife to rethink about the extension of their relationship, while at the same time guiding them to live separately also. And by doing this, the law allows them to free space and independence to think about their future path. And it is the last option available to both the spouses for the legal breakup of the marriage. So, under Section 10 of Hindu Marriage Act 1955, it provides for judicial separation for both the spouses. So, Section 10 of Hindu Marriage Act says those who are married under the Hindu Marriage Act 1955 they can claim the relief of judicial separation by filing a petition. Once the order is passed, they are not bound to have cohabitation. So, after this, I'm explain the concept of divorce. So, what is divorce? So, divorce means putting an end to the marriage by the dissolution of marital relation. It is the legal dissolution of marriage by a court or any competent court. After divorce, parties can no longer be husband and wife. The decree of divorce allowed each of the parties to have fresh marriage as they like. In the modern days, divorce is allowed for the spouse if they cannot live in compromise to each other. Under the Hindu law, divorce is governed by the Hindu Marriage Act 1955. So there are some grounds of divorce. So both men and women can apply for divorce on the following ground. So the very first ground is mutual consent, cruelty, adultery, desertion, conversion, mental disorder, communicable disease, renunciation of the word, and last when the spouse is presumed dead. The Indian Divorce Act 1869 recognizes only one ground of divorce, which is available for the husband, and that is adultery of the wife. The wife can sue for divorce on any of the following ground. The husband had converted to another religion and taken up a second wife, and for cruelty, desertion, disorder, and mutual consent also available for. But the scenario has been changed from 2001 and provided 10 grounds for divorce available for both husband and wife. So, according to Section 10 of Indian Divorce Amendment Act 2001, any marriage solemnized whether before or after the commencement of the Indian Divorce Amendment Act 2001 may, on a petition presented to the district court either by the husband or the wife, be dissolved on the ground that has since the solemnization of the marriage the respondent has committed adultery, has ceased to be Christian by conversion to another religion, or has been incurably of unsound mind for a continuous period of not less than 2 years immediately preceding the presentation of the petition, or has been for not less than 2 years immediately preceding of the presentation of a disease of incurable from leprosy. And the Hindu Marriage Act 1955 lists 9 grounds for divorce ranging from adultery, desertion, cruelty and conversion and such others to being infected with communicable disease. These are some additional grounds available to the wife apart from the maintenance provision under the Criminal Procedure Code 1973. The breakdown grounds are the same as under the Special Marriage Act 1954, and so is the provision for divorce by mutual consent. And divorce under the Muslim law is largely non-judicial. The grounds are categorized under the two heads: unilateral divorce by the husband and the divorce at the instance of the wife but with the consent of the husband. But as we already know, Supreme Court recently said triple talaq is not integral to religious practice and violates constitutional morality. And hence, by a majority of 3:2, the practice of talaq-e-baddat is banned. And triple talaq is set aside, but the right to divorce by wife is still unrecognized greatly in India. After the Shah Bano case, Indian government enacted the Muslim Women Protection of Right on Divorce Act 1986 but did not recognize the right to divorce by wife. Therefore, the right to obtain judicial divorce is available to the wife alone. Section 2 of Resolution of Muslim Marriage Act 1939 stated that a woman married under Muslim law shall be entitled to obtain a degree for the dissolution of her marriage on any one of the more or the grounds mentioned under this section.